Thank you for joining me. This video is intended to be an introduction to the sources of contract law of the United States of America, with the help, of course, of Ian Ayres and Gregory Class. Most contracts in the United States are governed by state law. Therefore, it is important to note that there is no single U.S. law of contracts. There are instead 50 laws of contracts, which spread among the 50 states, plus separate laws of contracts that correspond to the District of Columbia, Puerto Rico, the U.S. Virgin Islands, and other U.S. jurisdictions. It must be noted that there is a federal contract law for contracts with the federal government. This federal contract law will be covered in subsequent videos. Said separate laws of contracts differ from one another in very important ways, although in my humble opinion they can be learned as a whole without much difficulty. Also, which makes it not so difficult to study and comprehend as a whole, these bodies of law spring from one single source, as much of the law of the United States does, and that is the English common law. There is one main exception, although in my opinion there are others which I will expose briefly, and that is the state of Louisiana, whose contract law derives from the French Civil Code, given the influence of France in that part of the world. So, as these laws have grown and changed throughout the years, courts and legislatures have, notwithstanding, looked to one another for guidance and to a small number of national authorities, which we will discuss in this segment. So this, again, is proof, in my humble opinion, that the contract law of the United States, of the 50 states and the other jurisdictions, can be grasped in a short period of time by the average legal scholar. So while it is important to keep in mind local differences, it can be said that there is a distinctive U.S. law of contracts. In other words, yes, there is a different body of laws, at least 50 different bodies of law, but we can say nonetheless that there is a distinctive U.S. law of contracts. So it's very important to note that except when displaced by statute, and I was erroneously led to believe by studying law outside of the United States that this rarely occurred, the general law of contract in the U.S. is a product of judicial decisions in individual cases. This form of lawmaking is one of the most important inheritances from England, although it is not unique to the United States of America. English law of contract has emerged largely, again, from the decisions of the common law courts, together with those, of course, of the competing chancery court, which will be discussed further on in this video. But it is important to note that these chancery courts operate, and we will discuss them shortly. Now, although these courts have proceeded on a case-by-case basis by adjudicating individual controversies, they did not and do not act without guidance. So that being said, important sources for the common law of contract in England and in the United States have included Roman law, most significantly Justinian's Corpus Juris Civilis. Justinian was perhaps one of the first, if not the foremost, progressive Roman leader. He made many breakthroughs in making Roman law more progressive. Canon law has also been a source in England and in the United States, and that is the law of the church, of course. In later videos, I will discuss why that is not a good thing. And what is known as the law merchant, which is customary law developed by merchants in their dealings with one another. It must be noted for the new legal scholars that customary law is law, and it is derived from the customs of merchants in their relationships. It turns into law if it is identified and proven as universal and repetitive. Now, the most important concept, or principle rather, which is derived from all of this, is the principle of stare decisis, which is, in my humble opinion, the most important principle in common law systems. This principle requires that courts follow the holdings of earlier judicial decisions, and we will elaborate more ahead. This is meant, and I cannot stress enough the importance of it, that judicial adherence to this principle has meant that over the course, in fact, of centuries, there has emerged a judicially created and significant, well-defined body of legal rules. The core of U.S. contract law and of other U.S. contract law, the same goes for England and other parts of the world as well, we're not unique in this regard. The core U.S. contract law remains largely a creature of the common law, and this is of utmost importance in introducing the law of the United States of America. So, contract law lives in the records of judicial decisions, and that may lead the viewer to believe that therefore it is difficult to find. And even some practicing attorneys believe that. It is not difficult to find. I hope I can show you how. This being said, treaties and other secondary sources, and I will explain secondary sources later, have had a very significant influence on the development and harmonization, if you will, of not just the law of contract in the United States, but of law in the United States in general. The two most important treaties have been and remain to this day Samuel Williston's, an erudite of American law, treatise titled The Law of Contracts, first published in 1920, and Arthur Linton Corbin's, another erudite of American law, Corbin on Contracts of 1950. Now, Williston's work has a formalist approach which emphasizes fixed rules and principles, making it of easy learning, in my humble opinion. So we can't oversimplify what the works are, but they both have detailed discussions of the case law with a great array of theoretical reflection on the underlying principles. And throughout the years, both have had multiple new editions and new editors, and each has expanded into chronological volumes. Now, while Williston and Corbin's treaties are not law, and this is very important, they enjoy very much so persuasive authority with courts. Now, it must be said that even more important uh, than these individually authored treaties have been the restatements of the law. Now, uh, Samuel Williston, who was one of the authors of the restatements, said that the endeavor of the restatement, or the restatements rather, is to restate the law as it is, not as new law. So the end product of these restatements is strongly normative, which makes them clear and concise. The restatement of contracts, which is referred to as the first restatement, has been very influential and has been cited in thousands of judicial opinions. One must see Herbert F. Goodrich's and Paul Walken's The Story of the American Law Institute 39, published in 1961. So I can't state enough that the primary purpose of the restatements is to restate the law as it is, not as it should be. In other words, it is ontological, not deontological. Notwithstanding, they contain some innovations, probably the most significant of which is the increased recognition of reliance as a basis of liability. This is not as complicated as it may sound, and I will explain reliance as a basis of liability in the clearest way possible. Reliance as a basis of liability is a measure of compensation which is given to a person who has suffered economic harm for acting in reliance on a party who failed to fulfill an obligation. So again, it must be emphasized that for all the persuasive authority of the restatements and importance that they have had in the development of the common law, they are not the law. They represent the collective judgments, might not be the term, but the collective judgments of a highly respected body of legal experts regarding what the law is, although in very few instances what it ought to be. So these restatements are more ontological than deontological. They provide especially clear and carefully drafted comments um, of legal rules. Uh, they make for a clear, concise, um, well redacted body of statements of legal rules. The first effort of codification came with the Uniform Sales Act. The next major effort was the Uniform Commercial Code, or UCC, albeit it took a different approach than the Universal Sales Act. Just like the Uniform Sales Act, the UCC is a model statute. In other words, it becomes law only if enacted by a state legislature. So, whereas the Uniform Sales Act dealt only with the sales of goods, the uniforms, um, the UCC, the Uniform Commercial Code, has covered and covers a wide range of commercial transactions, including the sales of goods. To this date, 49 states and the District of Columbia, um, and I believe the U.S. Virgin Islands have enacted the Uniform Commercial Code, or UCC. Louisiana, following its tradition of authentic law, has only adopted, to my knowledge, Articles 1, 3, 4, uh, and 5. So the UCC tends to depart from the common law. It's more normative. And although the UCC statutes um, only govern commercial transactions of specific types, uh, some of their new rules have influenced the subsequent development of the common law of contract generally. It's a unique scenario in which a code influences common law very much so. It is very important to note that the National Conference of Commissioners on Uniform State Laws, um, who created this code, um, have amend it with frequency, and usually the states enact these amendments. It is very important to note that the NCCUSL website keeps an updated list of all uniform rules that this organization has promulgated, um, as well as the most recent amendments um, and which states have enacted these. It's very important that the um, new legal scholar um, take a look at these. It is very important to note that the NCCUSL website keeps an updated list of all uniform rules that this organization has promulgated, um, as well as the most recent amendments um, and which states have enacted these. It's very important that the um, new legal scholar um, take a look at these. I apologize for the holes in my wall, but given the hopefully objective nature of these videos, I had to remove a, uh, a plaque of mine which has some political significance, and I don't want it to be an issue in terms of judging my objectivity in these sessions. I keep on forgetting to do this. So it's not to say that the United States is a nation state um, which tends to adopt international law. We uh, tend to uh, not ratify very many treaties, and when we do, we don't tend to follow them. But that's a whole different story for a different discussion. Again, the subjective nature of that comment has something to do with the plaque which was over here and I removed for the sake of um, objectivity. So it must be noted that um, there have been two developments in international commerce um, law that have been significant uh, under United States law. As of August of 2011, if I'm not mistaken, the United States Convention, excuse me, the United Nations Convention on Contracts for the International Sales of Goods, from here on in CISG, had been ratified by 77 countries, including, and this is unique, uh, the United States and the other NAFTA trading partners, being Canada and Mexico. Whereas Brazil and the UK, to the best of my knowledge to this date, have not ratified the convention. I could be wrong. Now, the CISG applies to contracts for the sale of goods between parties who do business in different countries when both of those countries have ratified the convention. In other words, when the governments of both of those countries have ratified it. If they haven't ratified it, it does not apply to the party uh, which does business or is legally domiciled in that jurisdiction. The United States even went so far as to make um, um, the convention preempt the law of sales of the United States, which is Article 2 of the already discussed UCC. Now, the second very important development in international um, commerce was that in 1994, the International Institute for the Unification of Private Law, known as UNIDROIT, UNIDROIT, finalized the UNIDROIT principles of international commercial contract. It's accurate to state that the document is a restatement. Again, I want to emphasize the value of the restatements for learning and understanding the law. Um, the restatement of international contract principles. In other words, UNIDROIT principles are not law, but they purport to respond to international needs and practices and can be adopted by the parties as the law of contract, or what is known as Latin, pacta sunt servanda. Now, I must clarify that there may have been um, closer revisions to this date, but the principles of UNIDROIT, excuse me, were revised and updated in 2004, and in May of 2011, the Governing Council of the United Nations formally adopted the third edition of UNIDROIT principles in 2010. If you'd like to get a better angle of what these principles are, I would suggest seeing Michael J. Bonnell's text titled From Unidroit Principles 1994 to Unidroit Principles 2004, a further step towards a global contract law. It's a text from 2004. It's very useful. So this is the end of this segment of the principles of contract law in the United States of America. The following video will be the commentary of law and equity in contract in the Introduction to Contract Law in the Studies in Contract Law by Ian Ayres and Gregory Class. Thank you very much for joining me. I hope this was informative, and I'll see you in the next episode, which should be the comment by Ayres et al. On law and equity in contract. Thank you very much.